Good afternoon. My name is Kim Stanger. I'm the head of our firm's healthcare section, and we're here to talk to you about HIPAA Business Associates today. This is actually the next in our series of HIPAA presentations, and it actually began last December, but mostly here in February. In December, my colleague Matt Sorensen talked about HIPAA risk assessments. In February, he talked about the security rule. Last week, we talked about the privacy rule. Today, we're talking about business associates and agreements. And next week, we'll be talking about responding to HIPAA breaches. If you missed those prior webinars and would like to go back and listen to those, you can access those on our healthcare website. Hopefully that screen there, you can see it on the screen, the website for that. This is what we're going to talk about today, why you should care about business associates and business associate agreements. Who are business associates? Because a lot of times I get questions about, gee, do we need a business associate agreement with this person or that person? What must business associates do? Not only for covered entities, what you need to make sure that your business associates are doing, but if you are a business associate, what are your obligations? We'll talk about liability for business associates and subcontractors, and we'll finish up talking about some additional resources. I've given you a whole bunch of written materials, including a copy of the slides, the Office for Civil Rights, which is the HIPAA police, their sample terms for business associate agreements. It's not actually a business associate agreement, but it contains kind of the required terms, and it's their best guess, and it really has become the standard baseline for business associate agreements. I've also given you the OCR's guidance on HIPAA and cloud computing, which provides a lot of guidance when it comes to doing business associate agreements. We'll talk about that in just a minute. I've given you some different documents that I've prepared, including a business associate decision tree to help you identify those entities that are business associates, and an article on complying with HIPAA. If you're a business associate, this gives you a brief summary of what your obligations are. A checklist for business associate agreements. So if you get a business associate agreement in, or you want to check and make sure your business associate contains the required elements, this contains a checklist of those terms that you need to make sure are in there, along with some recommended additional terms you may want to at least consider. I've given you a checklist for security rule compliance. So if you're a business associate, you're going to have to comply with the security rule. What does that mean? This is a checklist that explains to you what those security rule requirements are. And finally, if you want to avoid business associate agreements, I've given you an article that I talk about what are those situations where business associate agreements are not required. Those written materials, you should have received a copy of those or a link to access those. If you didn't, just let Laura know. I sent on the chat feature her address, or shoot me an email. If you have questions during this program or afterwards related to this webinar, feel free to shoot me an email. Just make sure you reference the webinar so I make sure that that's what I know what you're asking about. With that said, let's talk about HIPAA and business associates. Why should you care? Well, because of potential liability under the HIPAA rules. Because HIPAA applies to, as from the very beginning, it applies to covered entities, which include healthcare providers, not all healthcare providers, only healthcare providers who engage in certain electronic transactions. That also applies to health plans, including employee group health plans with 50 or more participants or that are administered by a third party. So even if you are a healthcare provider, but you also have a separate employee group health plan that has 50 or more participants or is administered by a third party, that health plan also has to comply with HIPAA, just as it's a separate covered entity. So just like all the stuff that a healthcare provider would have to do, that health plan is generally going to have to do. And in the wake of the Omnibus Rule and the HITECH Act, HIPAA now applies directly to business associates of covered entities. When HIPAA first came out back in 2003, HIPAA only applied, based on the statute, it only applied to covered entities. And so there were concerns about, well, what about these entities with whom the covered entity shares its protected health information, maybe management companies, maybe auditors, those types of entities. HIPAA doesn't apply to them. What happens to their health information once it goes to those other entities? Well, the government said, well, we can't, HHS said, we can't directly extend HIPAA to cover those other entities because the statute said it only applies to covered entities. And therefore, what we are going to require covered entities to do is covered entities, before you can make these disclosures to these business associates, you have to have in place a business associate agreement that requires those business associates to comply with a lot of the requirements under HIPAA. And that's how business associates were sucked into HIPAA. Now, the rules changed, however, when the high-tech came out and the final HIPAA omnibus rule came out in 2013. HIPAA now also applies directly to business associates. You still have to do that business associate agreement. That's still a carryover from the old days. But even if you don't have a business associate agreement in place, the HIPAA now extends directly to business associates, and those business associates can be directly liable for HIPAA penalties. Now, in addition to that, covered entities have to be concerned because covered entities may be liable, vicariously liable, for what their business associate does under certain circumstances. And if you are a business associate who is using a subcontractor, then you as a business associate may be vicariously liable for what your subcontractor does if certain conditions exist. We'll talk more about that in just a minute. Well, what are those penalties? Well, you can get hit up with criminal fines. You can actually go to jail. That doesn't occur very often, although it has occurred. Most often you're concerned about the civil penalties. And these civil penalties, again, they can be levied against the covered entity. They can also be levied directly against the business associate. Those penalties are anywhere from $100 to $50,000 per violation. If you acted with willful neglect, it's a mandatory fine of at least $10,000 to $50,000 per violation. If you, if you acted with willful neglect but you correct it within 30 days, it's a fine of $10,000 to $50,000 per violation. If you act with willful neglect but you don't correct it within the 30 days, then it's a mandatory fine of at least $50,000 per violation. That is huge, especially when you consider that each person's information that was improperly used or disclosed, that's a separate violation. Those penalties can add up awfully quickly. That's the bad news. The good news is, if you do not act with willful neglect and you correct the situation within 30 days, then that is an affirmative defense to HIPAA fines. They can't fine you for HIPAA violations in that situation. The key here is you want to make sure that you're not acting with willful neglect, that you have put in place the policies and safeguards and provided the training you need to document that you didn't act with willful neglect. If you can do that, you can avoid HIPAA penalties. You may not be able to avoid some of the consequences of HIPAA violations, but you can at least avoid the HIPAA penalties. Now the government is serious about this HIPAA stuff. You look at some of the penalties that have been issued over the past year or so, anywhere from $5.5 million down to several tens of thousands of dollars depending upon the type of conduct. Now I wanted to highlight a couple of these because the government has really been focusing on business associate relationships. You look at that fourth one down. You had a situation where a business associate lost an unencrypted backup tapes of 14,000 persons. In that particular situation, the government entered a settlement not with the business associate, but with the covered entity. They determined that the covered entity was liable for failing to review and update their business associate agreement to include the privacy and security requirements. The covered entity really didn't do anything wrong when it came to the data, other than it failed to have an updated business associate agreement in place. They had a business associate agreement, but the business associate agreement was not updated to include the terms that were required by the omnibus rule. And the government came in and said, hey, you owe us $400,000, even though it was your business associate that lost the information. The lesson there is you need to make sure that you've got business associate agreements in place and that those business associate agreements are updated to include the terms that were required by the 2013 Omnibus Rule. A couple of other situations we'll talk about later, but the general rule is that the covered entities aren't vicariously liable for business associates unless that business associate is acting as the agent of the covered entity. And so we felt relatively comfortable that the covered entity's exposure was going to be limited. But then we got a couple of cases last year where, again, the covered entity was tagged based on the misconduct of the business associate, where there was no business associate agreement in place. In one of the situations, you had a business associate who lost the x-rays of 17,000 patients. In that situation, the government, instead of going after the business associate, or in addition to going after the business associate, they tagged the covered entity. Even though the covered entity wasn't the one who lost the data, the government said, hey, covered entity, you're liable because you did not have a business associate agreement in place, and therefore pay us $750,000. In another situation, it's even more egregious, you had a situation where the business associate lost a laptop containing 9,400 patients' information. And again, in that situation, it was the business associate who engaged in the wrongdoing, but nevertheless, the government said, covered entity, you are liable to us because you did not execute a valid business associate agreement, and you have to pay us $1.55 million. That, to me, is particularly egregious for a couple of reasons. One is, hey, business associates, under the omnibus rule, the business associates have to comply with HIPAA regardless of whether you have a business associate agreement. So what difference does it make if you don't have the business associate agreement in place? Because the business associate's still liable for it. What justification is there for imposing those penalties? Well, the government may say, yeah, but we want to make sure that the business associate knew of what their responsibilities are, and that's why we want you to have the business associate agreement in place. Well, okay, I kind of get that, except in this $1.55 million case, who was it? Who was the business associate that lost it? It was Accretive Health. Who's Accretive Health? Well, they're the same Accretive Health that got tagged a few years earlier as a business associate. They had to pay $2.5 million for failing to violate HIPAA, or for violating HIPAA. In that situation, obviously Accretive Health knew what they were doing. They knew they were obligated to. So what difference did it make that they didn't have a business associate agreement in place? I think that those are pretty draconian, terrible decisions by the Office for Civil Rights, but nevertheless, we're stuck with them. The lesson there is that you need to be aware of, if you're a covered entity, you need to be aware of your business associates and their business associate agreements, and make sure that you've got valid, updated business associate agreements in place. If you are a business associate, you're not off the hook. You can still get hit up directly for business associate or for HIPAA violations. For example, there was an entity where a business associate lost an iPhone. The iPhone was unencrypted, and it contained a bunch of patients' information. In that situation, the business associate got hit up with fines of $650,000, or at least a settlement for $650,000. And as I mentioned in the past, business associates have also been hit up for penalties, including Accretive Health that had to pay $2.5 million. What are the lessons? Again, if you are a covered entity, make sure that you have business associate agreements in place with your business associates. Otherwise, there is a potential that you could effectively be held vicariously liable for what the business associate did. In addition, you need to ensure that your business associate agreements are updated to comply with the 2013 Omnibus Rule requirements. Among those materials I provided to you today is a checklist of required terms for business associate agreements that is updated to include the Omnibus Rule requirements. You can use that checklist to compare your business associate agreements and make sure that they're up to snuff. If you're a business associate, you need to ensure that you comply with the HIPAA security rules and the business associate agreement terms. We'll talk about that in a little bit. All right, so we've talked about, well, why do you need to worry about it? Next, who are business associates? With what entities do you actually need to get business associate agreements? Well, HIPAA defines business associates as entities that create, receive, maintain, or transmit protected health information on behalf of a covered entity to perform not all functions, but certain types of functions. A function or activity that's regulated by HIPAA, which would include treatment purposes or healthcare operations, which is extremely broad. It applies specifically to certain types of identified services like billing or claims management, legal services, accounting services, or consulting services. HIPAA is defined, the definition of business associate defines, it's defined to include health information organizations, need prescribing gateways. It applies to data transmission companies if they routinely access protected health information. Let's talk briefly about that. With your internet service provider, generally you don't need a business associate agreement if they do not routinely access protected health information, if they are simply a conduit for the information. We'll talk more about that in just a minute. you have to have your business associate agreement in the wake of the Omnibus Rule. The Omnibus Rule made it clear that HIPAA applies to entities that create, receive, maintain, or transmit protected health information. Therefore, data storage companies, like cloud computing or off-site storage facilities, you are going to need a HIPAA business associate agreement, even if they do not access protected health information or the data is encrypted. We'll talk more about that later. And you need it for patient safety organizations. Essentially, the practical result of all of that is if you, as a covered entity, contract with or have some other entity create, receive, maintain, or transmit protected health information on your behalf, you got to assume that they are a business associate agreement. Conversely, if you're an entity that contracts with a covered entity, whether it's a healthcare provider or a health plan, including employee group health plans, to create, receive, maintain, or transmit protected health information as part of your duties for that entity, then you are a business associate. Now, it could be, you may have a situation where a covered entity is acting as a business associate. So maybe sometimes, a lot of times, the hospitals will provide management services to local physician clinics. If they are, then that, even though the hospital is a covered entity, it may also be performing business associate functions and may need a business associate agreement for those services. In addition to covered entities and business associates, HIPAA also applies to subcontractors of business associates. So in the course of performing those services for the covered entity, if a business associate subcontracts some of those functions, so that subcontractor is going to create, receive, maintain, or transmit protected health information, then that subcontractor is also going to be a business associate, and that subcontractor also has to comply with all the business associate rules. So you've got a covered entity, it's a healthcare provider or a health plan. If it shares or contracts with the business associate to provide the create, receive, maintain, or transmit protected health information for it, it is a business associate. If that business associate further shares that information or contracts with subcontractors to do something with that protected health information, then that subcontractor is also a business associate. Now, there are some circumstances where entities are not business associates. Let's talk about each of those. First of all, members of a covered entity's workforce are not business associates. They're your employees. Members of your workforce are entities that you can control. They're your employees. They're your agents. They're entities that you have control over if you're a covered entity. For those entities, you do not need a separate business associate agreement with them. They are not business associates. They're members of your workforce, and you don't need a separate business associate agreement for each of your employees or agents. Now, there may be a situation where you even have a subcontractor that you decide to treat as a member of your workforce. Maybe you have, well, the example that the government uses, maybe you have a software developer that accesses your information, and the government says, hey, if you've got this software developer who accesses your information to provide services for you, but they are doing that on-site under your control, then you may elect to treat them as a member of your workforce. And if they're a member of your workforce, you would not need a separate business associate agreement with them. Now, there's good and bad with that. If you're the business associate, the subcontractor in that situation, the contractor in that situation, that's good for you. You don't want to have to sign a business associate agreement. If you are a covered entity, however, you have to be aware that you're vicariously liable for what your workforce members do. So if you decide to go that route, just remember that if that person messes up, then you're going to be vicariously liable for what they do. All right, the next one. Entities who do not handle protected health information as part of their job duties, they're not your business associate, even though they may come in contact with protected health information. The classic example of that is like your janitor. You have your janitor come in and they're cleaning up the office. They may see protected health information in the course of what they're doing. But you don't want them doing anything with that protected health information as part of their duties. It's not like, hey, company, come in there. We want you to do the janitor stuff. Come in, clean the trashes. And by the way, while you're doing that, would you mind taking a look at our protected health information just to make sure we've got that all recorded? No, you don't want them doing that. You don't want them touching your protected health information. And therefore, those janitors are not your business associates. Mailmen, you know, if you're handing the stuff to the FedEx guy, well, you don't want him looking at your stuff, so they are not your business associate. It's only those entities that you want to do something with your protected health information who are business associates and for whom you would need a business associate agreement. The next exception, entities that receive protected health information to perform functions on their own behalf and not on behalf of a covered entity. So, for example, you may submit your credit card statements or things like that to a credit card company or to a bank to receive payment. Now, that information you're going to be submitting will contain protected health information, including information concerning the patient's account numbers and things like that so that you can get paid. But when those entities are performing those services, they're not doing that on your behalf. They're doing that on their own behalf. They're doing that as a payor. In that situation, they are not your business associate, and you would not need a business associate agreement with them. The classic examples are banks and third-party payers. When those third-party payers are performing services and paying claims, they're not doing it for you, as you all know who've tried to contract with them. They're not doing it for you. They're doing it because that's their business. They are not your business associate, and you don't need a business associate agreement with them. Now, it may be that in addition to performing certain claim services, maybe they are going to perform services as your business associate. Maybe they're going to come in there and do some kind of provide some third-party administrator services for your own employee group health plan or something like that. If that's the case, then you may need a business associate agreement with them in that situation. But when they're performing services just on their own behalf, not on your behalf, they're not your business associate. Other healthcare providers are not your business associate while they're providing treatment. So if you're sending stuff off to a lab or sending stuff off to an imaging center, well, that lab and the imaging center, they're just healthcare providers providing their own treatment. They are not providing those services on your behalf, and they are not your business associate. You don't need a business associate agreement to these referring labs or referring providers, those types of entities. If all they're doing is providing treatment, then they are not your business associate, and you don't need a business associate agreement with them. Now, it may be that that other healthcare provider is providing business associate services to you, and if they are, then they are your business associate, unless they're members of an organized healthcare arrangement. The classic example again, you may contract with another hospital to come in and provide some management services for you, or you may contract with another provider in your area to share a receptionist or do something like that. In those situations, they may be providing business associate agreement or business associate services for you. If that's the case, you would need a business associate agreement with that other entity, even if they are a healthcare provider. The key there is, are they performing services for you as opposed to treatment services on their own behalf for the patient? Next, data transmission companies that do not routinely access protected health information. If that data transmission company is merely a conduit for the transmission of that information, they don't routinely access that information to perform services on your behalf, then they are not your business associate, and you don't need a business associate agreement. So your internet service provider, your phone company, if all they're doing is just transmitting that data without ever going in and looking at it, then they are not your business associate, and you don't need a business associate agreement with them. In contrast, if they are maintaining that information, so it's a data storage company, a cloud service provider, if they're maintaining it, then in that situation, they are your business associate, and you need a business associate agreement with them. The difference is the transitory nature of their contact with the information. If the information is simply just flowing through them, then they're not a business associate. If they're actually storing that information for you, then they are your business associate, even though they may not access the information. If they're still storing it for you, then they're your business associate. Now, in the commentary that accompanied the omnibus rule, they recognize that, like phone companies and things like that, they may maintain data for a certain short period of time, and that doesn't necessarily convert them into a data storage company. The question is, you know, are they accessing on a regular basis? Do they maintain it other than just for a very, very brief period of time? And finally, members of an organized healthcare arrangement are not business associates in the conduct of services on behalf of the business associate or that organized healthcare arrangement. The classic example of this is, for example, the hospital and members of its medical staff. Those members of the medical staff may engage in peer review and other administrative services on behalf of the hospital, but the government says, look, at what they're doing, they're really all part of this organized healthcare arrangement that comes together to engage in these coordinated type of services. If it's part of this organized healthcare arrangement, those members of that organized healthcare arrangement are not business associates of each other when providing those types of services. In that article that I gave you about avoiding business associate agreements, it talks more about these exceptions. So if you are in a situation where you're an entity, you don't want to be a business associate, you don't want to incur those liabilities, you don't want to sign a business associate agreement, you may look at this article and see, okay, do I fit within the business associate definition, or do I fit within one of these exceptions through which I can avoid entering into a business associate agreement? In the documents that I provided to you, I've given you a business associate decision tree that allows you to go in there and kind of analyze, okay, is this entity a business associate? Do I need to have a business associate agreement with them? In the interest of time, I'm not going to go through that, but it just kind of walks you through those steps. Let's talk briefly about the cloud computing, because that is a hot topic. Before the omnibus rule, those data storage companies, the cloud computing companies, probably were not business associates. In the wake of the omnibus rule, they are. There's no doubt about it. If you've got a cloud service provider, the government issued very helpful guidance concerning contracts and business associate relationships with cloud service providers. I've given you a copy of that. Make sure you read that, because it gives you some very specific guidance in dealing with those cloud service providers. Some of the highlights are that those cloud service providers are business associates if they store protected health information, even though they may not access the data, and even though the data is encrypted and the cloud service provider does not have access to the key. Before this guidance came out, I made what I thought was a very good faith and strong argument that, hey, if you're giving that data, encrypted data, to this service provider and they don't have the key, then that's really secure data and they should not be considered a business associate. Well, the OCR basically came out and said, well, they may not be able to access the information, but they've still got it. They've got other obligations to maintain the integrity and the availability of the information. Therefore, we want HIPAA to apply to them. So, no, they are business associates. In addition, so you've got to have your business associate agreement with those cloud service providers. Now, it may be a situation where the cloud service provider, they're thinking, well, wait a minute, how do we know whether or not this entity that sends us the information, we're not looking at it, we don't know whether we're getting any protected health information. And under HIPAA, we're liable as a business associate even if we don't have a business associate agreement. So this isn't fair. We're going to be liable for HIPAA when we didn't even know we were liable for HIPAA because we didn't know we were getting that data. In this guidance, the government said, yeah, okay, if you didn't know you were getting protected health information, then you're okay. But once you get that notice, then you've got 30 days to correct the situation after getting that notice. And as long as you correct the situation within 30 days, then you're not going to get hit up with the HIPAA penalties. All right, let's talk about what are the business associate obligations. Well, in general, the business associate, if you're a business associate or a covered entity, you've got to execute a business associate agreement. The business associate has to comply with the terms of a business associate agreement with the covered entity. That business associate agreement has to contain certain terms that are required by HIPAA. We'll go through this real briefly. In addition to that, under HIPAA, the business associate has to comply with the security rules if it accesses, creates, maintains, or transmits electronic protected health information. So all that stuff that you guys have to do as covered entities with your ePHI, your business associates have to do it. That means they have to appoint a security officer, perform and document a risk assessment, implement the required safeguards, execute agreements with any subcontractors they're using, maintain written policies and procedures, and train personnel. That's only if they have the electronic protected health information. If they don't have electronic protected health information, then really the security rule doesn't apply and it's no big deal. If, however, they are getting that information electronically, then they're going to have to do all that stuff. Now, for most of your business associates, that's probably not a big deal because they're big enough to do it. But if, for example, you're using an outside coder to help you as an independent contractor, and they're getting that information electronically, well, hey, that means that they are your business associate. That means that that coder's going to have to comply with all of these requirements. And I'll bet you they're probably not. They probably don't have the capability to do that. What are some options? Well, one is you still make them sign the business associate agreement and they undertake that liability. Another is you could decide to treat them as a member of your workforce, so no business associate agreement is required under that circumstance. But remember, the downside is you may be vicariously liable for what they do. In addition to complying with the terms of the BAA and complying with the security rules, those business associates have to comply with the minimum necessary standard, meaning that they can't use or disclose more than the minimally necessary information that's required for a particular purpose. And they've got an affirmative obligation to report breaches of unsecured protected health information to the covered entity. We'll talk about that more in just a minute. All right, let's talk about that business associate agreement. Now remember, the covered entity has to execute a business associate agreement with its business associates, even though the business associate is already liable under HIPAA and has to comply with the HIPAA terms regardless of whether a business associate agreement is in place or not. But you still got to do that business associate agreement. If you are a business associate and you subcontract out any of the services involving the protected health information, you need to have a business associate agreement with your subcontractor. That business associate agreement kind of sets the parameters of what that business associate can do with the information, and that business associate has to comply with the terms of that business associate agreement. Well, who's liable for getting those business associate agreements in place? Well, the covered entity, it has to make sure there's a business associate agreement with its own business associates. When it comes to subcontractors, it's the business associate's responsibility to make sure they get the business associate agreement in place. The Omnibus Rule Commentary specifically says it's not the covered entity's responsibility to make sure business associate agreements are in place with the business associate subcontractors. It's the business associate's responsibility to make sure that they have agreements with those subcontractor business associate agreements. Now remember, part of the requirements under HIPAA and the business associate agreement is that that agreement between the business associate and the subcontractor can't contain terms that vary or contradict the agreement between the covered entity and the business associate. So you need to make sure that the agreement between the business associate and the subcontractor mirrors the requirements for the covered entity, for the contract between the covered entity and the business associate. That's a problem because sometimes that contract between the covered entity and the business associate may have terms, may have unique terms, or there may be unique limits on the use or disclosure of the protected health information by that business associate. That business associate may have its own form subcontractor agreements it likes to use, but if those subcontractor agreements don't contain the same restrictions or limitations that are found in the agreement with the covered entity, then there is a potential HIPAA violation in that situation. So those make sure that your business associate agreements mirror in the terms of the agreement between the covered entity and the business associate. What are the required terms? Well, they're set forth in the regulations, 45 CFR 164.502E and 504E. They're also set forth in that checklist that I provided to you, but they're essentially this. First, they've got to establish the permitted uses of the protected health information. They have to state that the business associate may only use or disclose the information as allowed by the business associate agreement or otherwise required by law. You may, if you want to, allow the business associate to use the information for its internal management or administration purposes. You're not required to, but you can, and that's not a HIPAA violation if you choose to allow them to use them for those purposes. But the business associate may not use or disclose the information in a manner that would violate the privacy rule if done by the covered entity. So you've got to be aware of situations where the covered entity has limited its own use or disclosure through, for example, its notice of privacy practices or agreement. So you may have a situation where the covered entity has put in place limitations or restrictions that are more strict than HIPAA would require. Maybe that covered entity has agreed that it's not going to make certain disclosures under its notice of privacy practices, even though HIPAA would allow it to do it. If that's the case, then the business associate agreement with the business associate can't authorize the business associate to use that information in a manner that would violate the notice of privacy practices from the covered entity. That business associate can't use or disclose the information in any manner that would violate HIPAA if the covered entity did it. So you need to be aware, if you're a business associate, beware of what limitations or restrictions the covered entity has placed on the use or disclosure of its protected health information. That business associate agreement, additional required terms, it's got to require the business associate to implement safeguards to protect the protected health information. It does not specifically require them to implement the privacy rule safeguards, but they do have to comply with the security rule requirements, meaning that business associate is going to have to perform and document a risk assessment, implement administrative, technical, and physical safeguards, execute subcontractor BAAs, maintain written policies and documentation, and train personnel. Most times your business associate agreement does not specify that they have to do those things. Instead, it'll just say that you've got to comply with the requirements under the security rule. That business associate agreement will require the business associate to make certain reports to the covered entity. Any breaches of unsecured protected health information under the HIPAA breach notification rules. In addition, they have to report not only breaches that are reportable under the breach notification rule, but the business associate also has to report to the covered entity if there's any use or disclosure of protected health information that's not allowed by the business associate agreement. By the way, that may not even be certainly may not be a reportable breach. It may not even be a violation of HIPAA, that use or disclosure, but if that use or disclosure is not consistent with the terms of the business associate agreement, then that business associate has to report that improper use or disclosure to the covered entity, and that would itself be a violation of the business associate agreement and would subsequently be a violation of HIPAA. In addition, they have to report security incidents. I'm going to talk more about security incidents a little bit later when we talk more about those notification requirements. The business associate agreement has to require the business associate to cooperate in providing individuals with access to protected health information that's maintained in their designated record set as necessary for the covered entity to comply with its requirements under 45 CFR 164.524. It's got to require the business associate to cooperate with the covered entity in admitting records that are maintained in a designated record set as required by HIPAA. It's got to require the business associate to cooperate in providing an accounting of disclosures of protected health information that's maintained in the designated record set. For those of you who don't know this rule, this says that an individual, a patient, has a right to receive an accounting of certain disclosures that have been made concerning its information. Not all disclosures, but only certain disclosures. And that covered entity, and ergo its business associates, have to log these improper disclosures so if that patient ever comes back and requests an accounting, that they've got the information to provide. The way that it works is if the business associate has an improper disclosure, it's got to log that and have that available so that it can disclose it to the covered entity if the covered entity needs it in order to make an accounting to the individual. That business associate is going to have to log the following information. Generally, it's improper disclosures that are violations of HIPAA and certain disclosures for public safety or government functions, including the information that they're going to have to disclose or the date of disclosure, the name of the entity receiving the disclosure, the description of information disclosed, and it's got to describe the purpose of disclosure. All right, that business associate agreement also has to have provisions that state if the covered entity delegates its functions to the business associate, that business associate has to comply with HIPAA as to those functions. So, for example, if the business associate agreement requires the business associate to provide the required breach notification rules, that business associate has to comply with all of the breach notification rules that would apply to the covered entity. The business associate agreement has to require the business associate to make its internal records available to HHS for inspection, Health and Human Services. It's common to put in a provision in there that requires the business associate to also make the records available to the covered entity, but that's actually not required by HIPAA. It's got to require the business associate to execute business associate agreements with its subcontractors, and as mentioned, you need to make sure that those subcontractor agreements parallel the terms in the agreement with the covered entity. It's got to authorize the termination if the business associate violates the terms of the business associate agreement, and upon termination of the business associate agreement, it's got to provide for the return or destruction of all the protected health information if it's feasible. If it's not feasible to return or destroy the information, that business associate has to continue to comply with the terms of the business associate agreement and HIPAA with regard to any protected health information it retains. Those are the required terms. Again, I've provided you with a copy of the OCR sample business associate agreement provisions, which really have become the baseline, the standard for business associate agreements, but there are usually additional terms that you want to include in your business associate agreement. If you are a covered entity, you're probably going to want to include or at least consider including the following additional terms. Now, these are terms that are not required by HIPAA, but they are terms that are quite often included in business associate agreements to protect the covered entity. For example, you're going to probably want to require the business associate to report breaches or improper disclosures within a certain period of time. Generally, you as a covered entity have to report breaches to individuals. If they're a reported breach, you've got to do it no later than 60 days. Well, you don't want to wait to 60 days until you get the notification from the business associate. In fact, you want it as soon as possible, because if you correct the situation within 30 days, you can avoid HIPAA penalties if you didn't act with willful neglect. So normally, you're going to want a provision in there that says that the business associate has to respond and notify you of any improper use or disclosure or breaches within X days, maybe 3 business days. If you get a request for a patient to access their information, you need to go to the business associate to get a copy of that information. You may want to require the business associate to respond to those requests within, again, a certain number of days, maybe 5 business days or 10 business days. You want to make sure that you as a covered entity get that information in sufficient time that will allow you to comply with any of the deadlines that apply to you in responding to the patient. You may want to require the business associate to implement certain policies, including privacy policies. Remember, HIPAA already requires them to implement security rule policies, but maybe you want to require them to implement privacy rule policies. You may want to require them to encrypt or implement other safeguards just to call it out to them, even though they're required to under the security rule. You may want to require the business associate to carry data breach insurance, covering any acts or omissions or violations of the business associate agreement. And you may want to include terms concerning the type of insurance or the amounts of insurance, like $1 million or $3 million limits. You may want to require the business associate to notify individuals of breaches. So normally under the HIPAA rule, the covered entity is the one who has the responsibility to notify HHS and individuals of reportable breaches. Maybe you as a covered entity want to shift those costs and that burden onto the business associate. So if the business associate is the one responsible for the breach, then that business associate is the one who has to bear the costs and provide the notice to those affected individuals, or at least cover your costs from doing that. You may, if you're going to use that kind of a provision, you may want to only require them to do that if you request them to do that, so that you have control over the type of notification that's going to be provided. You want to consider requiring the business associate to defend and indemnify you as the covered entity for any losses or claims or lawsuits or things like that that you may be subject to because of what the business associate or their subcontractor does. You want to confirm in your agreement that the business associate is acting as an independent contractor and not your agent, because you want to make sure that you're not vicariously liable for what they do. The general rule is if they're an independent contractor, you as a covered entity, you're not vicariously liable for what that business associate does. On the other hand, if they are your agent, then you're vicariously liable. So you want to make sure that your agreement specifies that they are acting as an independent contractor. We'll talk more about that in a few minutes. You may want to require the business associate to assume any liability for the subcontractor so that you don't have to sue the subcontractor. Instead, you can go directly against the business associate. You may want to allow yourself the opportunity to terminate the underlying services agreement if they violate the business associate agreement. You may want to require the business associate to obtain your consent before they send any of your protected health information offshore or contract with subcontractors offshore. Those subcontractors may not be liable to HIPAA or subject to jurisdiction, and therefore you may want to make sure that you control whether this data is going offshore. You may want to give yourself the right to inspect and audit to ensure their compliance. You will certainly want to require them to cooperate in HIPAA investigations or actions. And you may want to require that the business associate represent that they're not excluded from Medicare or Medicaid, because if you're contracting with entities that are excluded from Medicare or Medicaid, that could create some issues for you. Those are the types of terms that you as a covered entity want in your agreement with business associates. If you're a business associate, those are probably the types of terms that you're going to want to include in your subcontracts, particularly if they're in the contract with the covered entity. Well, what about a business associate? If you're a business associate, you probably don't want all of those other terms we just talked about, or you would try to limit those terms. In addition, as a business associate, you may want to include these types of terms in the agreement. You want to first condition any obligations on your status as a business associate. It may be, a lot of times, the covered entity comes in and they want you to sign a business associate agreement even though you really aren't a business associate, because the covered entity either doesn't really know who is or who aren't business associates, they're really not educated in this stuff or sophisticated, or they're just playing it safe. So they want to have everybody sign a business associate agreement even though they don't satisfy those obligations. Now, you as a business associate, you don't want to sign those if you don't have to, for two reasons. First, you don't want to assume the contractual liability under the business associate agreement. Second, you don't want to admit you're a business associate and subject yourself to the HIPAA fines and penalties by signing an agreement when you really aren't a business associate. Now, it may be that that covered entity says, business associate, we're not going to do business with you unless you sign this agreement. We really don't care whether you are a business associate or not. We're just going to play it safe, and so we're not going to do business with you unless you sign this agreement. You as a business associate may want to kind of waffle or at least protect yourself by saying something like, okay, I'll sign the agreement, but I'm going to sign the agreement in a manner so that it's conditional, that if and to the extent I am a business associate, then I agree to comply with the following terms and obligations. But you're not committing to yourself that you are a business associate. It's conditional upon you serving or you being a business associate. That at least gives you some potential way out if the government comes in there and tries to impose fines and penalties on you when you really aren't a business associate. You will want to probably contract with the covered entity that either they won't disclose any PHI to you or that they will not disclose protected health information unless it's absolutely necessary, because if you don't have protected health information, hey, there's not much of a HIPAA obligation there for you. You might want to put in there that they will notify you if they're going to provide protected health information to you so that you can put in place appropriate steps. You could require that the covered entity will not request you to do anything that's going to violate HIPAA and get you in hot water, that the covered entity get a representation that the covered entity has obtained any necessary authorizations. Remember, HIPAA prevents you from doing anything that would be illegal for the covered entity to do. Well, if the covered entity has to obtain certain authorizations before it can do something, you want to make sure that that covered entity got those authorizations before it asks you to do something. So you may want that type of a representation. You may want to require that the covered entity will not agree to restrictions on protected health information that will adversely affect your ability to perform services. Most of the time, if you're a business associate, you're entering into this agreements with the general understanding of, okay, this is what HIPAA requires or doesn't require. This is when I can disclose stuff and when I can't. In those situations, you don't want the covered entity going out and agreeing to a bunch of additional restrictions that are going to bind you and which, by the way, you may not know about. So maybe you want a provision in your agreement that says, hey, covered entity, you won't agree to any of these additional restrictions. Or at the very least, if you do agree to those, it gives us an option to terminate the business associate agreement or charge you for those additional restrictions that would come down upon us. You may want to provide for blanket reporting of security incidents. I'll talk about that more later. You want to specify that the business associate does not maintain a designated record set because if that's true, because you only have to comply with the access, amendment, and accounting disclosures for information that's maintained in a designated record set. If you don't maintain a designated record set, then you don't have to comply with those terms. You should reserve the right to terminate based on restrictions or other change that adversely affects the business associate's ability to perform. If that covered entity is out there putting in place a lot of restrictions that's going to increase your costs or effectively prevent you from performing, you want to have the right to terminate the agreement. You want to confirm that your subcontractors are not your independent contractor, or that they are independent contractors, not your agents, so you're not liable for what they do. You may want to, if there's an indemnification provision in there, make it at least mutual so that if you're sued because of something the covered entity does, that covered entity is going to reimburse you, and you may try to place some kind of a limit or cap on damages. If that covered entity has a damages provision in its agreement, you as a business associate you may want to cap those damages, like to the maximum amount of your liability insurance, or to a maximum of $50,000, or to the maximum amount of the monthly fee, 6 months of fees that the covered entity has paid to you under the services contract. Another way that you might cap that is that you will indemnify the covered entity, but only for those acts or services that are your fault, those acts or omissions that are actually your fault, and that your obligation to indemnify or defend the covered entity will be reduced to the extent that that breach results from the conduct of other parties. Those are just some things you may want to consider if you're a business associate about including in your terms. Those things are discussed more fully. There's a list in the sample document that I gave you, the checklist for business associate agreements. All right, when it comes down to actually negotiating that business associate agreement, usually it comes down to whoever has the most bargaining power. If you are the huge hospital system and you're contracting with a relatively small business associate, that huge hospital system is probably going to have the bargaining power, and you as a business associate may have to agree to terms you don't necessarily like, and you're just going to have to evaluate whether the risk is worth the benefit that you're going to get from doing that, engaging in that service. On the other hand, if you're a small provider and you want to contract with some massive EHR provider or a McKesson or some other huge entity out there, they may say, hey, here's our business associate agreement, take it or leave it. You may not have much of an obligation or much negotiating power in trying to put in these additional terms. Just, I guess, do the best that you can. All right, so business associate agreements, quick summary. Covered entities, when in doubt, execute a business associate agreement. It's just safer for you. You don't want to be like one of those groups that we talked about earlier on where they got hit up for fines or penalties based on what the business associate did simply because no business associate agreement was in place. So from your perspective, when in doubt, it's probably safer to get a business associate agreement in place. On the other hand, if you're a business associate, you don't want to assume business associate liabilities if you really aren't a business associate. So make sure that you review the contract and the circumstances to make sure that they really apply. Review the terms of your business associate agreement carefully. Consider or beware of terms that really aren't required by HIPAA. Beware of terms that increase liability or limit liability. Remember, if you're a business associate, you're going to have to comply with HIPAA whether it's in the business associate agreement or not. That's just the law. So, and if you're a business associate, you better darn well make sure you comply with the terms of the business associate agreement, not just HIPAA. Remember, once you sign that agreement by law and also by contract law, you're obligated to comply with the terms of the business associate agreement, even if it's more restrictive than HIPAA. So you need to make sure that you review and are aware of the business associate agreement terms and make sure that your workforce members understand and are aware of those additional requirements. If you violate that business associate agreement, you're going to have to report that to the covered entity, even if that violation was not a violation of HIPAA. All right. In the interest of time, I'm not going to go through the security rule in any depth. Just make sure that make sure you understand if you're a business associate, you've got to comply with the security rules. If you fail to do so, hey, you can get hit with fines and penalties. Remember that nursing home? It's a business associate who had an agreement with a nursing home. That business associate employee went in with an iPhone. They lost their iPhone. It was unencrypted because the business associate didn't put in place the required security safeguards. As a result, that business associate was liable to the tune of $650,000. So if you're a business associate, make sure that you comply with the security rule requirements. There's a bunch of guidance that is provided on the government's website, thehealthit.gov. If you're not familiar with that, you'd have to become familiar, and there's a lot of tools that will help you comply with the security rule. There's a risk assessment tool which will help you perform the required risk assessment. There are other guidance provided on that website that will help you comply with the specific security rule requirements. When it comes to the privacy rule generally does not apply directly to business associates, unlike the security rule, but it applies indirectly because remember, under the business associate terms, that you can't use or disclose the information in a manner that would violate the privacy rule if done by the covered entity. So you need to generally be aware of the business associate requirements and the privacy rule requirements to make sure that you're in compliance with your obligations under the business associate agreement. In short, the business associate can only access or use protected health information as allowed under the business associate agreement or applicable law. In general, that means that the covered entity and business associate may not access, use, or disclose protected health information unless it's for purposes of the covered entity's treatment, payment, or healthcare operations as required by other laws or for certain safety or government purposes as listed in 45 CFR 164.512. For everything else, you generally need a valid written authorization or, in the wake of the omnibus rule, the patient's written authorization or request that you disclose the information to a third party. In addition, you as a business associate, you've got to make reasonable efforts to limit the information you disclose to the minimum necessary to accomplish its intended purpose for the use or disclosure. That's the minimum necessary standard. Even though HIPAA and your business associate agreement allows you to make the disclosure or use the information, you can't use more than is minimally necessary for that intended purpose. The privacy rules net effect for business associates. Don't access, use, or disclose the information unless it's within the scope of your services agreement or business associate agreement, or you're directed to disclose it by the covered entity. Do not request access, use, or disclose more than is minimally necessary for the requested purpose. You've got to put in place reasonable safeguards. Again, the privacy rule does not specify that or directly apply to business associates, but you should still put in place these reasonable safeguards. That's important because if you have reasonable safeguards in place and there's what's called an incidental disclosure, somebody overhears something, somebody sees something, but you had reasonable safeguards in place, that disclosure was incidental to the services you're performing, well, that incidental disclosure is not a HIPAA violation, which means that you're probably not going to have to self-report it to HHS and the individual. You may have to report it to the covered entity if it's a breach and violation of the business associate agreement, but it's going to minimize your liability. We talked about your obligations of tracking disclosures in order to help the covered entity comply with its obligations under the accounting rule, essentially that the business associate has to track disclosures that are in violation of HIPAA and disclosures that are required by law to avoid serious harm or for certain government agencies. The HIPAA privacy rule will allow covered entities to de-identify information. Once that information is de-identified, HIPAA no longer applies to it. Well, what about you as a business associate? Can you simply de-identify that information and then use it, the information you got from the covered entity? The answer to that is not unless the covered entity authorizes you to. If the covered entity allows you to, specifies in the business associate agreement that, hey, part of the services or uses or disclosures that you can make of this information is to de-identify it, and once de-identified, then you can use it, that's okay, you can do it then. But you can't unilaterally just de-identify the information and use it. If you do that, that is, you are engaging in a use that wasn't authorized by the business associate agreement, and that is a violation under HIPAA. So if you want to use de-identified information you get from the covered entity, you need to make sure that's within the scope of the business associate agreement. There's nothing for you covered entities that require you to agree to that, but you may want to if you do. The business associate, the government has issued some guidance. There are some situations where maybe you're a business associate, you've got all this data, but the covered entity is not paying your bill. And you say, okay, well, we can figure that out. We can put a stop to that. Tell you what, we are going to hold your data hostage until you pay us. Or we are going to have some kind of a kill switch in the software we developed for you. So if you don't pay us, we're going to turn off that software and you're going to lose or you're not going to have access to your data. The government has said, can't do that. That is a violation of HIPAA, business associate, because under HIPAA, you've got to make sure that that data is available to the covered entity. And if you are preventing that covered entity from accessing that data, then you are in violation of HIPAA. Similarly, the covered entity may not agree with the business associate to terms that would prevent the covered entity from being able to access or obtain its protected health information either during or after the agreement terminates. The covered entity always has to be able to access the information. So you, as a business associate, you can't hold that hostage. You can't place any conditions or restrictions or prevent that covered entity from accessing the data, even if you would like to. All right, let's talk briefly about the breach notification rule. Under the HIPAA breach notification, if there is a breach of unsecured protected health information, the business associate has to notify the covered entity, and that covered entity has to notify each individual whose information is or has, whose unsecured protected health information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. In addition, every time you notify the individual, you're also going to have to notify HHS. The only difference is the timing of when you have to notify HHS. In addition, if the breach involves more than 500 persons, which is usually the case if there's a breach of electronic protected health information, then you're also going to have to notify local media. The key there is note that it is the covered entity who has the obligation to do those notifications. The business associate's job is to notify the covered entity. Then the covered entity has the obligation to make those required notices to the individual and the government. If the covered entity wants to, it could contract away that obligation and per contract require the business associate to make those notifications or bear the cost of those notifications on its behalf. The covered entity still has the ultimate statutory liability from ensuring that's done, but it could require that business associate to perform those notifications itself. Note that under the breach notification rule, you only have to notify if there's a breach of unsecured protected health information. If that data has been secured through encryption, you don't have to notify the individual because it's not a breach of unsecured protected health information, it's secured protected health information. On the other hand, if it is a breach of unsecured protected health information, the acquisition, access, use, or disclosure of information in violation of the privacy rule is presumed to be a breach unless the covered entity or business associate demonstrates that there's a low probability that the information's been compromised. We're going to talk more about all of those breach notification rules next week, and so I'm not going to go through those in any detail. Remember this, though, for you as a business associate, in addition to breaches that are reportable under the breach notification rule, those breaches of unsecured protected health information that have to be notified, you have to give notice to the individuals in the HHS, in addition to those breaches, the HIPAA rules require that you also have to notify the covered entity of uses or disclosures in violation of HIPAA and uses of disclosures in violation of the business associate agreement, even if that was not a violation of HIPAA. So you need to know the terms of your business associate agreement. And in addition, you need to notify the individual of security incidents. Now, security incidents is defined in the security rule as the attempted or successful unauthorized access, use, disclosure, modification, or destruction of information or interference with a system operation in an information system. Now, note that it's not only the security or the successful unauthorized access, it's also the attempted unauthorized access. Well, that gets to be a little bit problematic because if you talk to your IT people, they will probably tell you that, hey, we get hundreds, if not thousands of pings or port scans or things like that on a daily basis where people are maybe trying to attack our system. Under this definition, it would indicate that you've got to give those notices every time you get that. But that just simply isn't reasonable. We'd have to spend all our time on the phone just talking to the covered entities. I'll talk about that in just a quick second. Now, these are the general rules that are required by under HIPAA that you've got to make these disclosures. Your business associate agreement may actually impose additional requirements on the business associate in making those reports, as well as the timing for making those reports. Let's go back and talk about that security incident situation. In that cloud computing guidance that I provided to you, the government gave us some clarification on this whole security incidents deal. The bottom line is they basically said this: okay, when it comes to security incidents, yeah, you've got an obligation to report those. However, we're flexible. If you're talking about things just like pings or port scans that aren't successful, you could come up with different ways to provide that notice, maybe on a monthly basis or on an annual basis, so long as it doesn't represent a pattern that creates a significant risk. The bottom line is when your business associate agreements, you probably want to address the requirement to give notice of those security incidents so that you account for these unsuccessful pings, and you can change the notice requirements for those types of unsuccessful security incidents. All right, let's wrap up by talking about liability of the acts of the business associates or the subcontractors. Under the HIPAA enforcement rule, it states that a covered entity or business associate is liable in accordance with the federal common law of agency for the acts or omissions of a business associate or subcontractor that's acting within the scope of their agency. What does that mean? If that business associate or subcontractor is acting as your agent, as determined under the federal common law of agency, meaning generally that you have the right to control what they do, then you're going to be vicariously liable for them. The theory there is, hey, if you've got the right to control them, then you've got to control them in a manner that they're not going to violate the law. On the other hand, if they are an independent contractor and you don't have the right to control the method or manner and the way they do stuff, then you are generally not liable for what they do. You're not vicariously liable. So you want to make sure that you've structured your business associate agreements so that you minimize your exposure for the actions of business associates, or if you're a business associate for subcontractors, by ensuring that they are not your agent. Now, ultimately, the test is not what you put in the agreement by the classification, whether independent contractor or not, although that helps. It really comes down to how much control did you exercise over that individual. So if in your contract terms you have a lot of specific controls over them, you have the right to give them interim directions in how they perform their duties, then all of those are factors that roll into whether or not they are your agent. The bottom line is do what you can to maintain independent contractor status so you can avoid vicarious liability. Now, HIPAA does also go on to say that there are some circumstances where you can be liable. HIPAA's one thing is if you know of a pattern or practice of your business associate that they're out there violating HIPAA or violating your business associate agreement and you don't do anything about it, then you are liable for your own HIPAA violation. You're not vicariously liable for what they do, but you have violated HIPAA yourself. If you know that they're out there screwing up, then you need to take action in order to cure that. In addition, remember under those statutes that we talked about before, or under those settlements that came out before, in those situations, the government held the covered entity liable for essentially what the business associate did. Even though those business associates were independent contractors, if the business associate messed up that data or lost the data or violated HIPAA and there was no business associate agreement in place, then the government said, hey, covered entity, you're liable for violating HIPAA by failing to have that business associate agreement in place. So even though you're not vicariously liable for what that business associate did, if you did not have the business associate agreement in place, then guess what? We're going to still hold you accountable, not necessarily for their violation, but it's going to come back and haunt you. Bottom line again, make sure that you've got those business associate agreements in place. Now, some consultants out there will say, well, you ought to take steps to monitor, to ensure that your business associates are complying with HIPAA. What obligation do you as a covered entity have to actually monitor and to police your own business associates to ensure you're complying? The answer to that is you're not obligated to. Repeatedly, the OCR has said that it does not require a covered entity to actively monitor the actions of its business associates. Instead, in the original proposal, privacy rule proposal that came out, they did require you to monitor it, and when the final rule came out, they said, no, that imposes too much of a burden on covered entities. Instead, what we're going to require the covered entities to do is get a business associate agreement in place, and that business associate agreement requires the business associates to comply, and that's what you as a covered entity have to do. You don't have an obligation to actively monitor your business associates. You need to make sure that you have a business associate agreement in place. Now, if you've got that business associate agreement in place and you subsequently learn that your business associate is out there screwing up, then you better take steps to terminate the agreement or stop that. Otherwise, you can be liable, but generally you don't have this ongoing obligation to police your business associates. Well, even though you're not obligated, should you do that? Well, there's pros and cons about that. The benefit of doing that is it may be that if you monitor it, you can make sure that they're complying with HIPAA. On the other hand, if you undertake that obligation, which, by the way, can be quite burdensome, you probably have enough to do just ensuring your own compliance, let alone the compliance of your business associates. But there is some concern that the more obligation you take to oversee what your business associate is doing, then the greater the chance that they're going to be determined to be your agent, and you can be vicariously liable for them, or the more involved you are in that, if you overlook something or fail to take appropriate steps, then you can be liable for your own negligence. So if you undertake that duty to oversee what they're doing, and you do it in a negligent manner, it can actually increase your risk. So my general rule is be really careful about taking on too much obligation to oversee or police what your business associates are doing, because it may actually come back and haunt you. Under the rules, under the law, technically, you're just supposed to be able to have that business associate agreement in place, and that's what's supposed to police them. You're not supposed to do it yourself. Sometimes the business associate agreements will require that business associate to provide certain documents or participate in audits of its compliance. Again, the guidance that came out on cloud computing confirmed that there is no specific requirement that you as a covered entity must get audit documents or review the audit protocols that are done by the business associate. You can do so if you want, but it's an additional burden on you, and there is some argument that it could create some potential risk if you fail to act on this. All right, that is my overview of HIPAA and Business Associates. Real quickly, for some additional resources that are out there, the government's OCR's website dealing with HIPAA has a wealth of information, including some information about business associates. Just make sure that you remember that you check the date on it. The information that's there, for example, on this web page, it's got a summary of the business associate requirements, but that summary was drafted before the omnibus rule requirements that actually changed the rules somewhat. So just make sure you look at the date of that. We've also got a bunch of materials on our own website in addition to the materials that we provided to you. If you would like to access any of that information, including the past webinars or the other HIPAA materials, you can just go to our website there and you can access that stuff for free. That is it. Thanks for your patience today. Next week, we're going to be talking about responding to HIPAA breaches, and in March, we're going to be talking about cybersecurity issues in healthcare, which they all kind of go together. We appreciate your participation today. Hope it's helpful. If you have questions, shoot me an email or use the chat feature, and I'll respond to them. Just make sure you refer to the webinar. Thanks very much.